Hello friends, in the series on the income tax cases, today we will discuss a very important issue in regard to section 54 exemption. As all we know that section 54 exemption is available to the assessee if the assessee is able to invest the amount into the purchase of the residential property or the construction of the property up to the date of filing of the return, and if the assessee is not able to invest that amount, then the assessee has to deposit the amount into the capital gain account scheme, and after that the assessee can utilize that amount within the specified period. But what is the situation if the assessee is not able to deposit the amount into the capital gain scheme but ultimately utilized that amount into the purchase of the property? This issue has been taken by the Honorable Delhi ITAT G bench in the case of Miss Sarita Gupta versus Principal Commissioner of Income Tax, and this case has been reported in 109 ITR Tribunal at page number 373. The date of the judgment is 7th December 2023. In the present case, the assessment year is 1213. The assessee sold a residential property and invested the amount into the another residential property, although this amount invested was after filing the return of income by the assessee. The main lacuna on the part of the assessee was that the assessee has not deposited the amount into the capital gain scheme before filing the return of income and directly utilized that amount into the purchase of the residential property. The assessment proceedings were going on under section 147 read with section 148, and the assessing officer allowed the assessee exemption under section 54 since the assessee has invested the amount into the residential property. But after the assessment was completed, the Principal Commissioner of Income Tax was of the opinion that the order passed by the learned assessing officer is erroneous and prejudicial to the interest to the revenue solely on the basis that before investing into the property, the assessee has not deposited the amount into the capital gain scheme. Basically, there was a lapse on the part of the assessee to first deposit the amount into the capital gain scheme up to the date of filing of the return of income, and then he should have withdrawn that amount from that account and then he should have invested. So accordingly, CIT did the revision of the assessment order passed under section 147 in which the assessee was allowed the exemption. When this matter came before the Honorable Tribunal, the Tribunal said that in the present case, the assessee has complied with the basic conditions of section 54 subsection 1 and has invested the amount into the residential property. But the Commissioner of Income Tax on the hyper-technical basis has disallowed the exemption under section 54. The Honorable ITAT was of the view that in the present case there is no prejudice caused to the revenue by not investing in the capital gain account scheme by the assessee before investing into the residential property. So, Delhi ITAT was of the considered opinion that the assessee should have got the exemption under section 54 even if the assessee has not deposited the amount into the capital gain account scheme before investing into the residential property. Friends, this case is very important, but this case should not be used as a tool that the assessee has got some license to not to deposit the amount into the capital gain account scheme before investing into the property if the deadline of the return filing of the return has crossed. This type of cases should be used only in the exceptional cases where the genuine hardship should be there of the assessee not depositing the amount, but should not be used as a routine practice. At the end of this video, once again I am repeating the name of the case. The name of the case is Miss Sarita Gupta versus Principal Commissioner of Income Tax, and this case has been reported in 109 ITR Tribunal at page number 373, and the date of the judgment is 7th December 2023.